Hello, my friends. Hopefully, you all can hear me. Please, before I get too far down this victory lap, let me know if you can hear me by telling me where you all from. What states are represented tonight? I know it's late. It's 7:33 Sunday night, May 19th, but we just got a judge who gave us phenomenal news the night before the ATF's, actually a couple hours before ATF's new rule were to go into effect. So let me know if you can hear me and see this before I get too far down the rabbit hole. And I'll show you what just came out from a judge. All right. Hopefully y'all can see this. That would be wonderful. All right. Hopefully YouTube's putting me out of here. All right. It looks like we are live. Hopefully. Are we live? Can you guys hear this? Because I know they don't want this out. I think we're out. We're good. All right, we're good, good, good. People are saying we can see me now. It's just delayed for some reason. All right, so let's jump right into this because it's late. It's Sunday night. People are putting their kids to bed and whatever. Phenomenal news. I just got a phone call from Philip Van Cleve, who is the big boss man over at VCDL, the Virginia Citizens Defense League. We got a victory. A couple days ago, I did a video saying that a judge had fast tracked the lawsuit, which was Texas, Gun Owners of America, Virginia Citizens Defense League, Tennessee Firearms Association, and an individual, and that we were hoping for a decision before the rule went into effect. That rule was due to go into effect at midnight Eastern time. Well, guess what? It's not. We have a victory. I am going to show you here what we're talking about, guys and gals. First off, like the video, let people know what's going on. This is going to be difficult to get through the algorithm. Subscribe to the channel. My goal is 700,000 subscribers by my birthday, July 25th. We're close. So if you could just subscribe, double check your subscription, it would be wonderful. Here it is. This just came out. Let's see if I can make this bigger for y'all. All right, and this is the lawsuit that I talked about a couple days ago. Let's jump right into what they say here. Before this court is plaintiff's motion for a temporary restraining order filed on May 9th, 24. The defendant's response on the 14th. And having reviewed the materials, this court grants in part the motion. Accordingly, the defendants are hereby temporarily restrained from enforcing the regulations defined of engaged in the business as a dealer in firearms, herein after called final rule. Published there in the Register on April 19th against the plaintiffs, Texas, Jeffrey Tormey, all members of Gun Owners of America, all members of Gun Owners Foundation, all members of the Tennessee Firearms Association, and all members of the Virginia Citizens Defense League through June 2nd. So it's not totally dead. What this is doing is stopping it so that they can start the court case, so that ATF can't go after you and me for selling our guns before judges can look at this and say, does this pass constitutional water or muster or what? We know it won't. Here's the background real quick for those who don't know what I'm talking about. The United States Attorney General has the authority to enforce the Gun Control Act of 1968 and promulgate regulations necessary to enforce its provisions. And Congress, Congress and the Attorney General in turn delegated the Gun Control Act administrative and enforcement responsibilities to the Director of the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Page 2. The GCA imposes strict requirements on firearms dealers. We know this stuff, all right? I'm going to skip through this. We don't need to know all that. Let me shrink this. Legal standard, we know. Let's go to the analysis, because that is what we want to see here in the analysis. Plaintiffs, Louisiana, Mississippi, and Utah failed to demonstrate standing. So this is a different case. The court must address the threshold question, blah, 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 blah. All other plaintiffs now show standing. Why are you doing this to me? Let's see. Boom. However, plaintiffs Texas, Tormey, and the affiliated organizations have sufficiently demonstrated standing for the purpose of the requested temporary restraining order, and the court takes each in turn. First, Texas adequately pleads a cognizable pocketbook injury a prototypical form of injury in fact. Specifically, Texas illustrates how the final rule will prohibit otherwise eligible persons from obtaining a federal firearms license, thereby reducing the total gun sales at gun shows. And because Texas has a sales tax that applies to the sale of firearms at gun shows, it will sustain financial loss. That was the only way Texas could get in on this, by using the federal government's tax against them, is what that's saying. Okay. Moreover, in determining whether costs are irreparable, the key inquiry is not so much the magnitude, but the irreparability. So that means obviously Texas would be impacted by this, so they have standing in this. Okay, let me come back here. Boom. And to the top. Second, the individual, Tormey, he pleads that he has bought, sold, and traded firearms for many years as part of his large personal collection, and even previously purchased a table at certain gun shows in order to facilitate enhancing his collection. In response, defendants point to Susan B. Anthony, List versus Dryhouse, for their proposition that the threat of future enforcement against the plaintiff bringing a pre-enforcement challenge must be substantial. But that case treated the theft of future enforcement as a case and fact-specific and understanding the evaluating threats, blah, 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 blah. Here, the defendants have announced their intent to enforce the final rule and the Gun Control Act. So they're saying the ATF has already said they're going to start jamming people up over this rule. And the plaintiffs have identified a prior enforcement proceeding targeting conduct falling squarely within the final rule's ambit. Tormey is thus well situated to allege that the final rule may be enforced against him, and defendants do not deny, nor could they deny, that such an enforcement would result in irreparable injury if that occurred. Lastly, the organizations Gun Owners of America, Gun Owners Foundation, Tennessee Firearms Association, and the Virginia Citizens Defense League show standing. Under the doctrine of association, yeah, I'm tired. Associational, there we go, standing. An association may bring suit on behalf of its members when, one, those members would otherwise have standing to sue, which every American would here. Two, the interests it seeks to protect are germane to the organization's purpose. It's the Second Amendment. And three, neither the claim asserted nor the relief requested requires the participation of individual members. And that is all true. I'll go back. Come on. Why do you do this to me? All right. Here, if I can get this pain in the ass to work. All right. Here, three organizations, GOA, TFA, and VCDL, count Tormey, who has standing, as their member. Moreover, TFA and VCDL have provided declarations evidencing that they have specific members who will be impacted by the final rule because they have bought and sold firearms and wish to do so in the future without being improperly labeled as a dealer in firearms. And if GOA or TFA, I live here, VCDL, I'm a member. If you guys need me too, I have guns in my safe that I actually do want to sell. So if you need me, I'm available as well. Declaration of Philip Van Cleve, who just called me, shows that as well, and the same holds true for GOF. Okay. The GOA describes the former FFL whose retirement savings are now frozen in unsellable inventory. The defendants respond. All right, so we understand all this. Okay, I don't have to go through the whole thing, but I am going to show you one other part here. This is where the judge says that the plaintiffs are substantially likely to prevail on the merits. The final rule likely violates the APA, the Administrative Procedures Act. Judicial review under APA is limited to the administrative record. Please hit the like button, please, guys. Agencies are mere creatures of statute, must point to explicit congressional authority justifying their decisions. Okay? And we'll jump down to where it says, as such, courts are compelled to hold unlawful and set aside agency actions that are arbitrary, capricious, an abuse of discretion, or otherwise not in accordance with law or in excess of statutory authority. All of which applies here. All of it. The ATF can't make law. The Second Amendment protects this stuff, which means Bruin and Heller and McDonald and Caetano all apply. And we've been able to sell our own property that's been lawfully owned forever. ATF and Joe Biden seem to want to change that now. But they're not. At least not yet. Okay? Work with me. All right. As this is a question of statutory interpretation, the court begins with the text, United States v. Lauderdale County. And here, the final rule clashes with the text of the BSCA, the Bipartisan Safer Communities Act, in at least three ways. And then remember, this is the ATF, DOJ, and Joe Biden were saying the Bipartisan Safer Communities Act allows this. So this judge is saying it clashes in three ways. First, it asserts that there is no minimum number of firearms to actually be sold to be engaged in the business for the purposes of licensing requirement. You could just sell one and violate this. A single firearm transaction, or even a mere offer to engage in a transaction, may suffice. This is from the rule. While selling large numbers of firearms or engaging or offering to engage in frequent transactions may be highly indicative of business activity, neither the courts nor the department have recognized a set minimum number of firearms purchased or resold that triggers the licensing requirement. Similarly, there is no minimum number of transactions that determines whether a person is engaged in the business of dealing in firearms. Even a single firearm transaction or offer to engage in a transaction, when combined with other evidence, may be sufficient to require a license. And this is from the filing of our side. Okay? The Bipartisan Safer Communities Act says otherwise. The term engaged in the business means, as applied to a dealer in firearms, as defined in Section 921A, 11A, a person who devotes time, attention, and labor to dealing in firearms as a regular course of trade or business to predominantly earn a profit through the repetitive purchase and resale of firearms. It's italicized to show this is what the judge is accenting. He's accentuating this. The repetitive purchase and resale of firearms. But such terms shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. Okay, the defendant's proffered interpretation is severely undercut by 921A21C's use of 1, firearms in the plural, 2, the phrase regular course, clearly contemplating a series of events, 3, repetitive, meaning more than once, and 4, the section's exemption of sales, exchanges, or purchases in the plural. So, too, does section, come over here, next page, come on, baby doll, work with me, 921 alpha C, 821C require the purchase and resale of firearms, a conjunctive requirement that flatly contradicts the defendant's assertion that, quote, there is no minimum threshold number of firearms purchased or sold that triggers the licensing requirement. Second, please like and share, guys. Please like and share. Second, the final rule suggests that actual profit is not a requirement of the statute. It is only the predominant intent to earn a profit through the repetitive purchase and resale of firearms that is required. In other words, a person may repeatedly advertise and display firearms for sale, and therefore demonstrate a predominant intent to earn a profit from repeatedly selling and reselling firearms purchased, but never actually finding a buyer. So if you have a bunch of ads on Gunbroker, then you would be able to be arrested by the ATF here if you weren't an FFL. But Section 822 of the Bipartisan Safer Communities Act provides the term to predominantly earn a profit means that the intent underlying the sale or disposition of firearms is predominantly one of obtaining pecuniary gain as opposed to other intents such as improving or liquidating a personal firearms collection, provided that proof of profit shall not be required as to a person who engages in the regular and repetitive purchase and disposition of firearms for criminal purposes or terrorism. The negative corollary is obvious. While proof of profit is not required for criminal purpose or terrorism, it is required for all other cases. We'll jump down. It says, moreover, the mere fact that the word intent appears in the section does necessitate or even suggest that intent is all that is required. On the contrary, the section's usage of intent serves merely to distinguish the type of intent contemplated, namely, one of obtaining pecuniary gain. Action is needed too. Third, if I can get this over here, the final rule arbitrarily eviscerates Section 921A 21C's safe harbor provision, and that provision reads, the term engaged in the business shall not include a person who makes occasional sales, exchanges, or purchases of firearms for the enhancement of a personal collection or for a hobby, or who sells all or part of his personal collection of firearms. 18 U.S.C. 921A 21C. Nothing in the foregoing text suggests that the term personal collection does not include firearms accumulated primarily for personal protection. Yet that is exactly what the final rule asserts. In the rule, it says, the term personal collection shall not include firearms accumulated for personal protection, nor can defendant's position be supported by its own interpretive policy of implementing terms common meaning. All right, so I don't want to get too wordy on y'all. There's only 2 pages left I want to show you here. Boom, 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 boom. Go to the conclusion here. The conclusion says, the defendants are temporarily restrained from enforcing the regulations definition of engaged in the business as a dealer in firearms. Okay, against the plaintiffs Texas, Jeffrey Tormey, Gun Owners of America, the Gun Owners Foundation, the Tennessee Firearms Association, and the Virginia Citizens Defense League through June 2nd, 2024. The plaintiffs Louisiana, Mississippi, and Utah are excluded from the relief granted herein. Okay, let me take this off the screen here. So, thank you, Joe. Just saw that. Sorry, missed that. So that is huge, huge news. ATF's new rule has been stopped. It came out at 7:30. 4.5 hours before it was supposed to be effective. So that's huge news. I want to thank everybody involved in this case. As a member of GOA, as a member of Tennessee Firearms Association, as a member of VCDL, thank you, gentlemen and ladies who have taken up the fight here from those groups. Join these groups, guys and gals. Join them. It costs about a pizza, a trip through the drive-thru at McDonald's. Skip that and donate to these groups because they're kicking ATF's ass, and that is exactly what we want them to do. I hope you can do me a favor, like the video, share it so more people see it. Thank you for joining me so late on a Sunday night, but this was just too damn good to pass up. The ATF got their teeth kicked in federal court again for violating the Constitution, violating the Second Amendment, and they're going to be held accountable. They're going to lose this too. They're going to lose all of these rules. That's phenomenal. Thank you, guys and gals. Have a phenomenal night. God bless you. Never forget to say I love you to a loved one. You never know when that chance will disappear. All right? Trust me. I'll see you on the next one. You are your own first responder. Never forget it. There won't be a cop or a Fed ever where you need them when you need them. It's just going to be you. Take care, y'all.